So once again, thank you for joining us this morning. I'm pleased to be joined by Laura Windsor, the chair of our Labor, Employment, and Immigration section here at Williams Mullen. My name is Brydon DeWitt. I'm a partner in our Employee Benefits section. And Laura and I were exchanging emails a few weeks ago about, what do we think is going to happen with the new Trump administration? And that emails turned into this seminar. We thought our clients would like to hear what we thought. And so let's go to the next slide so we can do some housekeeping. If during this morning's seminar you have any questions, you can submit them through the Q&A feature here on Zoom, and questions will be answered at the end of today's presentation, time permitting. And if you have any technical problems hearing us, you can use the Q&A button to also address that, and our marketing team will help get you back online. Materials are this PowerPoint will also be sent to you by email later today, along with a link to a recording of this program. So if we can go to the next slide. And so here's what we're going to be talking about. Laura really is doing a lot of the heavy lifting this morning with employment and immigration issues. First, Laura is going to talk about anticipated changes in labor law, including the likely new priorities of the National Labor Relations Board. And then she's going to discuss the future of diversity, equity, and inclusivity, DEI, in employment and other anticipated changes in employment laws. And then finally, Laura will talk about increased scrutiny and attention to the enforcement of immigration laws and its impact on businesses. And then I'll be back to talk about where we see employee benefits headed under the new Trump administration with respect to the Affordable Care Act, with respect to retirement plans. There could be a Secure Act 3.0 coming, ERISA fiduciary duty concerns, and other employee benefits considerations. And so with that, I think I'm going to turn it over, go to the next slide. And Laura, it's all yours.
Well, as Brydon said, thank you all for joining us today. It's nice to see so many participants at our webinars. For those of you who aren't yet sick of me and Brydon doing presentations together, we do try and keep it engaging. So I hope that this will be informative to you. As Brydon said, we're going to start with labor laws. And if we can go to the next slide, please. So when I talk about labor laws, for those of you not familiar with the term, we're talking about issues pertaining to labor union management. And those issues are typically handled by the National Labor Relations Board and the Department of Labor. I'm glad I'm starting with this slide because I think it is the most crystal ball related. And it's because I think the Trump administration has had two different fronts. One is a very pro-business front, which tends to be anti-union, but also President Trump appealed to so many organized labor employees during the campaign, and I think it's going to be interesting to see how that balance goes. So the first item is we definitely believe that the National Labor Relations Board General Counsel will be replaced. The current General Counsel is Jennifer Abruzzo. We believe she will likely be replaced. For those of you following the news, you probably saw that one of the Democrat members of the board was voted down because largely two of the independent members of the Senate did not vote to approve. So what that means is that I do see that there's going to be a likely shift in the composition of the NLRB to a Republican majority. And if that is the case, I think we will see more employer-friendly rulings, particularly on issues like workplace policies, how unions are organized within employer sites, how elections are conducted, and how employers can respond to that unionization. So we'll see how that plays out. But again, I think that's probably a little bit of the pro-employer bent of this. Same thing with the quote captive audience meetings. These under the Biden administration, the NLRB banned employers from having mandatory meetings where employees would have to come in and employers could tell them how great their company was and why they didn't need a union. The NLRB recently banned that employers from being able to do that. We think that pendulum will switch back, and that the ban will be overturned and employers will have an opportunity at least to speak to employees about unionization. There also are currently in place very quick union election rules. If the union gets enough cards, then the employer almost effectively must recognize the union, or if they don't immediately recognize the union, then they have to pretty immediately run an election. So I think that the current rules that allow those quick union elections will likely be rescinded, giving employers more time to respond to organizing campaigns. I think this might strike the balance that the Trump administration is looking for between pro-business and pro-union representatives and union personnel. And similarly, we don't think that the NLRB will scrutinize workplace rules quite as much. As many of you know, the NLRB has been very active in the space of workplace rules, confidentiality provisions, non-disparagement provisions. We think they will likely take less of an interest in those going forward. But here's my crapshoot, the Secretary of Labor crapshoot. Trump supports Representative Lori Chavez DeRemer as the Secretary of Labor and is putting her forth as the nominee. Interestingly, she supported the PRO Act and the Public Service Freedom to Negotiate Act. She has historically got a very pro-labor stance. But she also voted to block the Biden's joint employer rule, which expanded employer liability. So it will be really interesting to see how much freedom she is given if she is the new Secretary of Labor to follow her policies or follow Trump's policies. And I think that is really going to be a very big pendulum swing. Let's go to the next slide, please. Yes, the next topic I wanted to discuss briefly is diversity, equity, and inclusivity, DEI, a hot topic. You see it in the news probably every other day, and then some general other employment law issues that we see. Next slide, please. So I think DEI is going to be the hottest topic that we see, at least in the first 6 months, maybe year of the incoming Trump administration. This has obviously been throughout the news. It was throughout the campaign. This belief that DEI programs actually have a reverse discriminatory effect on the workforce, and that candidly that they feel that the pendulum just swung too far in favor of DEI. And I've got some thoughts as to how I think that's going to work itself out. But before I get into that, I want to kind of talk very briefly about this concept of reverse discrimination. All workplace discrimination laws are effectively governed by Title VII, and there's the Age Discrimination Act, the Americans with Disabilities Act, et cetera. Title VII being kind of the big kahuna in the room. That is the one that prohibits discrimination on the basis of race, sex, national origin, religion, color. Important to remember under Title VII is that it doesn't protect any specific individual race or individual gender. It protects discrimination on the basis of race. And so where I see a logical kind of extension of that is that the courts and the EEOC and the federal agencies that administer these kinds of diversity and anti-discrimination programs may focus more on ensuring that no one race or gender or national origin is given a priority treatment. That if you are going to prohibit discrimination in the workplace, that prohibition extends just as much to Caucasian employees as it does to African American employees, as it does to men, as it does to women. And so I think that we will see some serious legal challenges to DEI programs on the grounds that they would argue that they are facially discriminatory in that they favor one race or one gender over another. This kind of got even more apparent to me when Trump picked for the Department of Justice Civil Rights Division, which is an extremely important division of the DOJ. He has picked Harmeet Dillon, who just Google her name and you will see a whole litany of discussions and policies and activities that she's been involved in to end so-called woke policies. And I promised myself that I would not make a drinking game where anytime someone said woke, you have to take a drink, because then we'd all be blotto for the rest of the day. But she has taken a very strong position on ending these so-called woke policies and affirmatively dismantling DEI in schools, government agencies, public institutions. As I mentioned, the Civil Rights Division is hugely important. It leads the government enforcement of discrimination laws in housing, employment, and education. It is the bulldog that enforces discrimination laws. And if those discrimination laws are being enforced in a different manner, that will obviously have huge ripple effects. So the affirmative action programs that many of you participate in, if you're a government contractor or a government subcontractor, in order to do business with the government, you must have an affirmative action plan. And history lesson that comes back from an executive order 11246, that was signed by President Johnson in 1965. It has since made its way, obviously, into federal regulations. But affirmative action programs are actually administered by the Department of Labor, not the Department of Justice, so not the Civil Rights Division. But again, remember what I said earlier about the Department of Labor, crapshoot. Don't know what direction that Department of Labor secretary might go in. But it would be easier to rescind an executive order, which one president can and often do, to rescind prior executive orders, but it's a lot harder to amend federal regulations. So I don't anticipate a huge change in how affirmative action programs are administered by the Department of Labor and the Office of Contract Compliance Programs, the OFCCP, but I think there is a chance that there will be less enforcement efforts. I know many of my clients are getting a lot of audit letters right now from the OFCCP. I think there's a lot of push to get those things done and in before the administration changes hands. But I think if anything, we might see less enforcement of affirmative action programs through the Department of Labor. As I mentioned, I think the EEOC, which is a division of the Department of Justice, might be more receptive to claims from non-minority groups alleging what some people call reverse discrimination. But for example, claims from men that they are being discriminated against and as to women, or Caucasians being discriminated against in favor of African Americans. So we might see more receptive treatment of those. We might see even more receptive treatment of non-LGBTQ individuals bringing discrimination claims because they feel like LGBTQ individuals are being treated more favorably. So we will see, I think, a lot of that. In our section, we also have a great team of education/employment lawyers. And our education lawyers advise that they anticipate also Title IX rollbacks on college campuses. We see that DEI offices are likely to have a reduced role or renaming or reprioritizing. And again, we do see reduced federal enforcement of Title IX protections for LGBTQ plus individuals. And again, just Google Harmeet Dillon and you will get a full view of what that might look like. Next slide, please. So general employment laws, and as Brydon warned you, I'm unfortunately going to be talking so I apologize in advance. You will hear from him again at the end. But general employment law changes, I think that there is going to be a return to a more business-friendly independent contractor classification. Now, I say that, but I don't want everyone running out and signing up independent contractors. I mean, you still will have to satisfy a multi-factor control test for determining if someone is truly an independent contractor as opposed to an employee. And please remember that state laws are not affected by anything that I'm saying. And so you want to carefully watch independent contractor classification, but I think it's going to go more back to that traditional multi-factor control test as opposed to the California-esque ABC test that almost makes it impossible to be an independent contractor. We do anticipate reduced wage and hour enforcement, and I think just generally reduced enforcement unless there are egregious violations, and because of the focus right now on government efficiencies, the so-called DOGE department that's going to be trying to make the government more efficient. So we might see less wage and hour enforcement actions from the Department of Labor. Of course, that doesn't stop my wonderful colleagues on the other side of the employment law bar from bringing claims on behalf of employees. The non-compete regulation that I know everyone was really freaking out about, justifiably, I think that one is likely dead. I don't think that the Federal Trade Commission's prior efforts to regulate or restrict non-compete agreements are going to have new life. This is another one of those areas that has traditionally been left to the states, and I think it will continue to be left to the states. The good news is that we won't have a one-size-fits-all non-compete ban at a federal level. The bad news is you have to know what the state laws are. And here in Virginia, we have pretty strict laws on non-competes. In California, for example, they are absolutely banned. So you will have to know your state laws. Paid family leave is dead. I just don't see that there's going to be any momentum to have a national paid family leave initiative, maybe in a small isolated pocket, but as in terms of amending the Family Medical Leave Act to make it a paid statute, where it is currently an unpaid leave statute, I don't see an aggressive push on that. Again, some state laws do require paid family and sick leave, so you'll want to check that. But this kind of keeps with the theme of the federal government doesn't have to regulate everything. The Trump administration is very focused on, states can decide. And I think this is one of those where they can quite easily punt to the states. If states want to provide more, then they can. So this one, minimum wage stagnation, it's still $7.25 an hour at a federal level. Here in Virginia, it's up to $12 an hour. It's and actually slightly higher than that due to cost of living increases. I think, again, we'll probably see that federal minimum wage stay $7.25. It'll be interesting to see how the Trump administration's plan on and our own governor here in Virginia's plan to not tax tips will have an impact on these kinds of issues. But I do not anticipate any federal push to increase the federal minimum wage. But please pay attention to your state laws. There is currently in place a Pregnant Workers Fairness Act, the PWFA. It was a pretty recent statute that was that went into effect that provides protection for pregnancy and childbirth related conditions. Of course, what Congress made, only Congress can amend, but I do anticipate that it is likely that Congress will amend the PWFA to potentially exclude leave related to abortion unless it's explicitly related to a medical emergency. As it stands right now, the PWFA is a little bit nebulous as to whether it covers abortion-related treatments and provides accommodation requirements for employers on that. All right, next slide. Wow. Okay, immigration laws. Now, I could have one of my immigration colleagues do an entire session on just the possible changes in immigration laws. We'll go to the next slide, please. Instead, I will give you a nutshell, but I will also plug my two colleagues, Earl Baggett and Tom Narvez, who just recently posted an article that's available on our website regarding I-9 practices and the focus of the Trump administration on I-9 compliance. So I would recommend to you all to please check out their very informative article on I-9 practices available on our website. But in a nutshell, yes, there's going to be more enforcement and more compliance requirements in the immigration space. And if you do nothing else, I think you should prepare now by reviewing your I-9s and conducting internal audits to ensure that you're in compliance with those I-9 requirements. for those of you who don't know what I-9s are, these are those forms that you sign within the first 3 days of your employment that basically certify that you are legally authorized to work in the United States and to work for this employer. We do anticipate increased scrutiny on undocumented workers and the I-9 compliance that goes along with that. The Trump administration has stated that it's going to first focus on criminal non-immigrants that are here unlawfully and not focus initially on workplace raids, for lack of a better word. But I think that there will be resources that are spent on those kinds of enforcement efforts, and we recommend that employers take care on their I-9 forms. When you are filing lawful petitions to have workers come to the U.S., H-1Bs, L-1s, et cetera, these non-immigrant visas, I think you are going to reasonably have to anticipate longer processing times and a almost automatic requests for evidence. This is their kind of request for additional information rather than rubber stamping approvals. I think there will be a lot more scrutiny of those non-immigrant visa categories to ensure that they truly fit within the law. We do anticipate that other humanitarian programs may be at risk, such as temporary protected status, national interest waivers, and STEM OPT programs. But that, I think, may be something that we see down the line in the Trump administration's efforts, maybe in the second half of the term. Next slide, please. And then just a couple of other little nuggets to share with you. We do think that there's going to be a lot more roadblocks for applicants to prove eligibility for visas, for visa extensions, for visa renewals. We do think more scrutiny at the airports and the train stations on coming into the United States. And the other thing I will just mention before I pass it to Brydon is there is a very real chance that there will be a potential return of travel bans. A lot of what's basing our discussion today is not only Trump 1, the first Trump administration, but statements that were made during the campaign. We don't think that Trump administration 2 is going to be a full redux of Trump administration 1. But there are certain commitments that he made during the campaign that I think it would be not looked on favorably if he did not at least try to push some of those through, travel bans and immigration enforcement being one of them. So let me pass to the next slide and pass it over to Brydon to talk about employee benefit laws.
Okay, thank you, Laura. So if we can go to the next slide. So I just want to discuss a few employee benefit law changes that are anticipated under the Trump administration. And the first has to do with ESG investments. So it's kind of been, if you Google ping pong ball and ERISA, you'll see the various regulations on environmental, social, and government's impact on ERISA plan investments, the ability of plan fiduciaries to take ESG factors into consideration when choosing plan investment options or investing ERISA plan assets. The Trump administration in 2020 issued regulations that require fiduciaries to solely look to pecuniary interests in selecting plan investments and plan investment options. And so this had a chilling effect on fiduciaries considering ESG factors when choosing plan investments. And then 2 years ago, the Biden administration issued new final regulations, kind of reversing the Trump stance, and said that plan fiduciaries may consider collateral effects of plan investment options. So if you had two investment options that equally serve the interests of plan participants, a fiduciary is permitted under the 2022 regulations to consider ESG factors in picking between the two options. So if a plan fiduciary believes that climate change will have a negative impact on society and the economy and ultimately harm plan participants, then if you have two investment options that are would serve the interests of participants, the fiduciary may take into account the ESG factors and select the one that meets those factors. So the anticipation is, with the Trump administration coming back, that we could see the ping pong ball getting hit back over the net into, you can't consider collateral factors. It's just financial, fund performance, fees. That's all you consider. You can't consider these collateral effects or ESG factors. And so it's anticipated we're going to get back. So the Biden era regulations will go away. So it kind of, whether you consider ESG for planned investments depends on who's in the White House, apparently, because we're getting this ping pong ball. The second thing we're looking forward to is Secure Act 3.0. So we've had the Secure Act in 2019, the Secure 2.0 Act passed in the end of 2022. And really, in my editorial view here, a lot of common sense changes where Congress recognized that our retirement system is based on defined contribution retirement plans of participants contributing to those plans. And these Secure and Secure 2.0 made those plans more attractive and available to workers. And now we're looking toward a Secure 3.0. And so more of a simplification of rollovers to make plan accounts, 401k accounts more portable, have default investment options for individual retirement accounts, possibly lowering the minimum age at which you can exclude workers from 401k plans from age 21 to age 18. And so we think we're going to see some legislation in the Secure Act. Moving on to the Affordable Care Act. It's possible, we saw under the Trump administration, the individual mandate was eliminated. The employer mandate, and I'm not making this prediction, but it's possible that we could see movement on the employer mandate under the ACA. If the employer mandate went away, it would really gut kind of under the structure, the foundation of the Affordable Care Act. But it's kind of on the table. If you are an applicable large employer and really enjoy completing the forms 1095C and 1094C, if that's something you really think is a lot of fun, I've got bad news for you. And this isn't really even a Trump administration. We have two pieces of legislation that have been passed by Congress, and President Biden is expected to sign, that really simplify some of the reporting requirements under the ACA. So the Paperwork Reduction Act provides that forms 1095C are only provided to employees upon request. Now, you would still have to file the 1095Cs with the IRS, but you would not have to automatically distribute a 1095C to every full-time employee. You would only have to provide the 1095C upon request. And then also the Employer Reporting Improvement Act has been passed by Congress, would give you more time to respond when the IRS sends you the lovely letter 226J claiming that the employer owes the employer mandate penalty, the ESRP, gives you 90 days to respond. And then also a 6-year statute of limitation for the ESRP. So the IRS couldn't come after an employer for failing to provide affordable minimum value coverage more than 6 years ago. So it would be at least kind of limiting that exposure for employers to 6 years. The ACA requires first dollar coverage of preventive care, and preventive care is every year there's a list of new preventive care options. With RFK Jr.'s involvement, we could see a different treatment of vaccines or certain vaccines as whether they must be covered by plans. And then there could be expansion of faith-based objections to certain mandated preventive care, such as certain vaccines. We also may see a callback of trans healthcare protections. The Affordable Care Act, Section 1557, prohibits plans that receive funding from the federal government, which includes plans that are offered on the exchange. So insurers that offer plans on the exchange are subject to the non-discrimination requirements. The Biden administration regulations treats discrimination against transgendered individuals as violating Section 1557. We may see a clawback of that under the Trump administration. With Republicans, they always seem to like defined contribution health care and health reimbursement accounts, health savings accounts were instituted under the second Bush W administration. And so it's anticipated that we could see an expansion of health savings accounts, higher contributions to health savings accounts, and perhaps more expansion of individual health reimbursement arrangement opportunities. So accounts where participants, employees put money into their own account to fund their own health care, as opposed to it being solely out of insurance. And then finally, there's talk about capping the federal income tax and payroll tax exclusion on health insurance premiums. So if this goes through, if depending on the level of the health insurance premiums, a portion of those premiums paid by employers would be taxable wages to the employee, and they wouldn't be able to run through a cafeteria plan if they exceed the cap. So I know we're 1031, but those are some employee benefits considerations. So if we can go to the next slide.
We did it. We made it through the entire Trump administration predictions in 31 minutes. So we thank all of you for joining us. I know that there was one question in the Q&A that I can answer with a yes or no. It was whether I believe that E-Verify will be the law of the land. And I think that that is an easy button that they will likely push to make E-Verify required. It is already required for many employers as well as in some states. So I think that's likely something that will happen. Well, Brydon, thank you again for jumping on my crazy wild idea that we get out our crystal ball and talk about what to expect when you're expecting a new president.
Okay, well, thank you everybody for joining us, and have a great day.
Thank you.